Good afternoon, everyone, and it is an absolute delight to see all of you here, and thank you so much for taking time out of your demanding schedule on what is turning out to be an amazing, memorable day here at Hofstra Law. And I want to welcome you. I really do sincerely, warmly welcome you, as I always do, those of you who are home at Hofstra, and those of you who have come home to Hofstra. And those of you who are visiting Hofstra, we are delighted to have you at this year's inaugural event of the Friedman Institute for the Study of Legal Ethics. Our institute manages the Friedman Social Justice Fellows Program. And this is, I have to tell you, I am so proud of the Justice Fellows. They are absolutely incredible. They're trained by some of the noted experts in the business, in the legal community, that they will be trained for 3 years here at Hofstra. They will be able, at the end of their training, to be thoughtful counselors and thought leaders who will be, I know, truly effective advocates to promote social justice and the public interest. My friends, I have found that I want everyone to really meet all of their professional goals, but what I have found the most fulfilling is serving the public good, and I hope that that's what will resonate with you as well. This year we have 12 very, very talented fellows. Ellen Yaroshevsky, Professor Yaroshevsky, talks to me about you often, and I know that you have been instrumental in organizing today's events. Because I am so proud of you, and I know Professor Yaroshevsky is so proud of you as well, and I know she's terribly disappointed that she can't be with us today, due to a medical issue in her family. And as I like to always say, and I had to say to her, your family comes first. We come a close second, but your family comes first. So if our fellows could please rise so that you could be recognized. You'll make me happy. Please do this. Thank you. Our event is also being co-sponsored by many of our absolutely terrific student organizations. The Asian Pacific American Law Student Association, the Black Law Students Association, Hofstra Law Women, the Immigration Law Society, the Latino and Latina American Law Student Association, the Muslim Law Students Association, Outlaw, the Social Justice Alliance, and the South Asian Law Students Association. Thank you all, and thank you for being so involved. We are honored, and truly honored, and I have been especially the beneficiary of his largesse, because during my tenure here at Hofstra, and many of you know, I consider myself a 3L since I've been here for 3 years, okay? That Professor Barry Scheck has come to the Hofstra campus on a couple of occasions. And as we all know, and I know you know this too, he is the co-founder of the Innocence Project that is truly internationally known for its groundbreaking work. I had the opportunity recently to speak at Lloyd's of London with regard to the commercial courts in the state of New York, and it was a really interesting conference that I attended. But believe it or not, we were talking about Hofstra Law, and we were talking about our involvement and about the Friedman Institute and about Professor Yaroshevsky. And also, of course, we were talking about Professor Barry Scheck. And I was proud to say that he was really wonderful to give his time and energy to so many students, especially those here at Hofstra. So he is internationally known, and today he will deliver a talk, and I know we're all anxious to hear lessons from exonerating the innocents. We are also pleased to have a gentleman that I have known in one variation or another. I probably know him and of his reputation more than he knows me, and that's a fabulous criminal defense lawyer who will be introducing Professor Scheck. Now, Mr. Barquette is the founding partner in Barquette and Epstein, which is a firm here in Nassau County. But I have to tell you, they are also known in all of the New York State courts as well as all the federal courts. Mr. Barquette specializes in criminal defense matters in both courts. He is known federally throughout the state and in other states, and he is known here in New York. He began his career, though, here in Nassau County as an assistant district attorney, which I know so many of you have aspirations of doing as well. Mr. Barquette has also handled some really high-profile cases. He has a long list of successes, including being part of the legal team that overturned the double murder conviction and secured the release from prison of Martin Tancliffe, who was wrongfully convicted of killing his parents and spent 18 years in prison. This is another place that our careers intersected, because at that time, that case was pending before the court where I was the presiding justice, the Appellate Division, 2nd Department, although I did not hear any Suffolk County criminal matters, and this case did come out of Suffolk County. Mr. Barquette is a frequent lecturer and commentator in the national media, and he has repeatedly been recognized by his peers for his work on behalf of his clients and honored with numerous awards. But I have to tell you this, and I am delighted to be able to thank him both publicly and personally for being someone who has graciously been a donor of scholarships here at Hofstra Law School. So Bruce, thank you so much for your support in all ways. So without further ado, please welcome Mr. Bruce Barquette.
Good afternoon, everyone. Just a quick nod to my former colleague and friend, Professor Fred Klein. We both were in Nassau County DA's office. He a few years ahead of me, but was certainly a mentor to me while we were both there. It's quite an honor to introduce Barry Scheck, because in my view, he is one of the heroes of the criminal defense world over the last 50 years. There's not another attorney who's had more of a dramatic impact on the criminal justice system than Barry Scheck. And I'm privileged to know him and be friends with him. We actually have played golf once or twice. And I'm kind of pinch myself when I stop and think about all the work that he has done and everything he's been involved in. And I've been lucky enough to both be a friend of his and a colleague that we've worked cases together. He was born in Queens, grew up at least partially in Nassau County, went to Yale School where he got a degree in American Studies and Economics, and went on to Berkeley Law School. And then he took all that education and all that ability and made a fortune at the Bronx County Legal Aid Society, if I'm not mistaken, who in that day I'm sure paid an enormous sum of money to talented young lawyers. He then became one of the youngest professors, if not the youngest professor ever, at Benjamin Cardozo School of Law. And he started something called the Innocence Project. And in the early 1990s, or maybe even before that, he had the insight to recognize that DNA would revolutionize the criminal justice system. And indeed, it has. And he took that insight and he was able to establish the Innocence Project, where over, I think the count is 340, roughly, men and women have been exonerated, taken from prison where they did not belong, and freed because of his work. It is truly an amazing legacy that continues. His work has pulled back the curtain on flaws in the criminal justice system, exposing misidentification by witnesses, police misconduct, false confessions, wrongful convictions, bad judges, frankly, shoddy defense lawyering from time to time, and has not only opened the gates of prison for those that he actually freed, but provided the basis to free others. Because before the Innocence Project came along, prosecutors and judges were loath to believe that wrongful convictions even happened, or believed that they were so rare as not to be concerned about. So because of his work, people like Marty Tankleff had a chance. We didn't have DNA for Marty, but the courts, the judges had to recognize that wrongful convictions occurred, that false confessions were an actual phenomenon. And all of that was because of the work of Barry Scheck in the Innocence Project. So it is a true honor to be able to introduce him. One other thing, he represented O.J. Simpson. And it occurred to me as I was thinking about the remarks today that many of you may not have been born when O.J.'s wife and Ronald Goldman were killed, and were relatively young when he was tried, I think in 1994, 1995. I was a lawyer then, been a prosecutor, criminal defense lawyer, and watched the proceedings and was stunned by the skill and charisma of this young lawyer from New York, who blistering cross-examination out in California. And that was my first introduction. I didn't meet him, but my first time I saw Barry Scheck was him taking apart the Los Angeles District Attorney's forensic team with his cross-examinations and the summation he gave on that part of the case. So it's truly, truly amazing work, and it's a thrill to introduce him. I'm sure you're going to love what he has to say. Barry?
Thank you very much. I wouldn't be here if I were you. I'd be watching the hearings. But in this day and age, we all have a TiVo. Now, I'm starting my phone because there's so much interesting things to say and share with you. And I'm going to stop after 30 minutes, and then we'll have some questions and discussion. I want to say hello to my friend Fred Klein, Mike Patrick. There's probably some others in the room I haven't noticed yet. I want to mention that Professor Yarashevsky, has just done a fantastic job with this institute, named after a truly great man, Monroe Friedman. And Ellen is somebody that I've worked with, for 30, 40 years, both when she was in private practice and at Cardozo Law School in various incarnations. And she did an enormous amount to help us start the Innocence Project, and frankly, she was the driving force in getting past two ethical rules, 3.8G and H. 3.8G says that if there's material evidence of innocence post-conviction, a prosecutor should disclose it, and 3.8H says that if there's clear and convincing evidence that a prosecutor should do something about it, if they know about it. And it's really, I believe that these ethical rules will one day, no matter who is on the United States Supreme Court, become constitutional rules. Because every state in the country now has a statute that allows one to prove innocence with newly discovered evidence. And in fact, if a prosecutor has material evidence of innocence in his or her possession, or certainly clear and convincing evidence, I believe that that will in fact be recognized by the United States Supreme Court as something that a prosecutor must disclose post-conviction. The notion that the obligation to disclose exculpatory evidence necessarily ends completely after conviction, I think is not true and will not stand. And the reason why I think those standards will one day become constitutionalized, to use a term that Judge Alito used in Padilla, the immigration case, Mike, as he can tell you all about it, is that we do have all these exonerations. So when my partner Peter Neufeld and I started the Innocence Project as a clinical program at Cardozo Law School in 1992, we just knew a lot about forensic evidence. We were on commissions that the first Governor Cuomo put us on and appointed. We had some expertise in serology and DNA evidence, and we started using it in cases, and we recognized almost immediately that not only could DNA identify people who had committed crimes, but they could exonerate people who had been convicted of crimes if we could go back and test that old evidence. But truth be told, because both of us had been public defenders in the Bronx with the Legal Aid Society and had been through this system, we knew that there had to be many more innocent people convicted than anybody ever believed. And now in retrospect, we know that's true. And the crazy thing is, why would we think otherwise? What have been identified as the causes of wrongful conviction that we at the Innocence Project work on in a policy way all the time: mistaken eyewitness identification, false confessions, unvalidated forensic science or just forensic science procedures which are incompetent or in some instances fraudulent. The prosecutorial and police misconduct, ineffective assistance of counsel, which frankly I think is one of the largest problems, because in all the movement around criminal justice reform that we've been lucky enough to see in the last maybe 10, 15 years, not enough attention is being paid to the defense function, because it is the overburdened defense function that has to be strengthened in order for progressive prosecutors, who I can tell you, I'm proud to say, are being elected all across this country. You can be the most progressive prosecutor. You want to do everything you can about bail reform, things to re-entry, efforts to reduce mass incarceration, but you can't do it alone. That is a myth, right? Everybody says, oh, the prosecutors are the most powerful people in the system. In many ways, that is true, although historically you'll see that's a comparatively recent development. But the bottom line is, the most progressive prosecutors, they cannot do it without community support. We can't do anything to fix this system unless we have community support, unless we have a defense function with court-appointed lawyers and certainly defender offices that provide holistic defense for people, that save families, that help with addiction, with all the problems that beset this system. And finally, when one talks about the causes of wrongful convictions, you cannot avoid the most difficult and crucial issue that we have not come to terms with in this country, and that is the issue of race. Now, I could talk a lot about that, but I want to just give you a bit of an overview of how this innocence movement is spread. And, you know, truth be told, we knew from the very beginning that all these issues that are implicated in wrongful convictions had to be, as part of the Innocence Project's agenda, legislative agenda, and as part of what I think is really a movement, we had to do policy reform at every stage. So far, there have been 362 post-conviction DNA exonerations. You can see that on the Innocence Project website. In 158 of those cases, the person who really committed the crime has been identified. That's like 47%, something like that. Now, let me tell you why we keep the DNA numbers separate, all right? And the reason we keep the DNA numbers separate is that nobody can really contest that, okay? People do not contest it. When you can exonerate people and then find the people that really committed the crime. On the other hand, this innocence movement, and it really is a movement, we now see since 1989, which is the date we use because that's when DNA first started being admitted to the courts. You should definitely look at the registry of exonerations by our colleagues. It's now housed at University of Irvine Law School, but started at the University of Michigan by Sam Gross, and Northwestern by Rob Warden, and now we have a whole new generation of people that are curating it. But you go to the registry, and the registry is a compilation of cases where people were convicted, new evidence of innocence led to their convictions being vacated, and then they were either acquitted after a trial, although very few times do these cases really go to trial subsequently, it does happen, or the cases were dismissed or they were pardoned by governors, right, as adjudication of innocence. And there are 2,226 such cases since 1989 in the registry. And by the way, that grows a lot. It doesn't just grow because there are more exonerations. It grows because when we go back historically, we're still finding more of these cases. There's a lot more out there. But when you look at all the cases in the registry, we're trying to do a much better job of going through that scientifically and rigorously to tease out more of these causes of wrongful conviction. So when I just glibly said police and prosecutorial misconduct, right? Well, there may be instances where prosecutors were accused of not disclosing exculpatory evidence, but the truth of the matter is they didn't even know about it, all right? Because it was in the possession of the police, let's say in a homicide file or something like that, and the prosecutor didn't know. So you can't call that prosecutorial misconduct. It turns out that it's really a failure to disclose on the part of the police, who do in fact have an obligation to disclose exculpatory evidence. Indeed, they're the ones that can be sued for violating constitutional rights. Prosecutors have absolute immunity for anything that takes place during the adversarial system. So we need to learn a lot more and tease out some of this data. We now have the Innocence Project, as I said, started in 1992. There are now 53 other innocence organizations across the country. I use that term for trademark purposes. Many of them, however, will use the name Innocence Project. We police that mark to make sure that these are credible institutions. But 53 of these institutions are across the country, most of them in law schools, because from the very beginning we realized that the best way to really open people's eyes to these problems in the criminal justice system was to work through law schools and law students and law professors, because you are the ones that are the next generation, and you are the ones that are going to deal with these issues in a profound way. And if we change your consciousness and we educate you about science and about ways of looking at this system that are different and more enlightened, frankly, then we will change things faster. So that was always our approach. Frankly, we could have done it differently. We could have just formed some big nonprofit at the beginning, but we didn't. We worked through law school's clinical programs. Now the Innocence Project still has a clinic at Cardozo Law School. We're still associated with it, but it is now an independent nonprofit entity. We employ 80 people. And as I said, there's 53 other organizations in the United States. We are the headquarters for this network. We provide the other organizations with support, but they operate independently and do an incredible job. And we also work with conviction integrity units. This is something that we helped invent, probably most prominently in Dallas in 2007, when Craig Watkins, an African-American defense lawyer, shockingly was elected district attorney in Dallas, and he immediately appointed somebody from an Innocence Project in Lubbock, and we all came down to Dallas and we helped get half the money to finance it from matching funds from the Dallas City Council. And it turned out in Dallas they saved all the biological evidence, so we gave a lot of exonerations. And it was also an office that really needed to have a re-examination of old cases. You should see the greatest American documentary about criminal justice probably ever made, called The Thin Blue Line by Errol Morris. And it's actually a story of a case involving Henry Wade, the legendary district attorney at Dallas. And Errol's one of the great filmmakers of all time, but you should really read that, see that movie. I used to teach a wrongful conviction course. I always started by showing people The Thin Blue Line, and you'll see most of the documentary techniques that have been used, forever. Now, one of the things that really jumps out at me, because we are, after all, talking while these hearings are going on, is, when I was listening to people say that, my God, how can we possibly make any kind of determinations when allegations arise about incidents that took place 20, 30 years ago? And we looked around at each other in the office and we were saying, that's all we do. Now, I mean, it's fair enough to say that if you can find DNA or some other kind of forensic evidence, we can now do a lot with fingerprints in databases and other things. If you can find DNA, that really does cut to the heart of the problem of finality. And that's why we have all these post-conviction DNA statutes passed and everything else. But the truth of the matter is, as any prosecutor or defense lawyer can tell you, whether you're a Republican or a Democrat, this has nothing to do with political partisanship. We're interested in doing the best we can in the legal system in terms of investigating matters to try to get the best approximation of the truth. Doesn't matter what political party you're on. Where's Bruce? Bruce is a Republican, right? I am a left-wing Democrat, always have been. But at the same time, the one thing that unites anybody that works in this system, whether you're a prosecutor, defense lawyer, or a judge, all of us working together professionally. And I think, by the way, I've always thought that the criminal bar were much more civilized with each other than the civil bar. Because when money is at stake and you have, I mean, it's unbelievable when I started doing civil rights cases to see what goes on. We were far more hospitable with each other and civilized in the criminal function. But you have to look at evidence, make inferences, and do the best you can to reinvestigate. So a few things. First of all, I have to, Judge Prudente, by the way, was enormously helpful behind the scenes, can I say that? In terms of getting past two really great reforms that the Innocence movement has always been behind. One of them having to do with eyewitness identification procedures that can reduce mistakes in that area, best practices procedures that we finally got passed in New York last year, and they've been in effect for about a year. We have to study those a little better, but we know from psychological scientific experiments that it's a great improvement over what we used to have. There's still more work to do there. And also videotaping of interrogation from Miranda warnings forward. This was all passed, and it's very hard to get things passed in the New York State legislative system. And so you need to have, there was a great commitment to this legislation from Judge Lippman, and Judge Prudente also had spoken out on this. It was part of the judiciary's recommendations. And if it weren't for that, believe me, if it weren't for everybody, we wouldn't have gotten this done. But let me just, and there was DNA in the Marty Tankleff case. There were hairs that were found on the desk of Seymour Tankleff, which by microscopic examination, the analyst said were actually hairs from Marty's mother, right?
Marty's mother and a wig, for lack of
Yeah, and a wig. Marty's mother, and it was part of the prosecution's theory that Marty's mother was killed first in this large house, and then he went into his father's study and killed his father, and that the hairs on the father's desk came from the mother, or came from the bedroom. And ultimately, we were able to show with forensic evidence that, in fact, Seymour Tankless was killed first, and the hairs on the desk, which microscopically the analyst said she had analyzed and were consistent with Arlene Tankless, in fact, were the hairs from Seymour. That's what mitochondrial DNA testing did. And I actually think we paid for that. Or whatever. But what I'm really saying is, by no means was that dispositive of this case that was decades old. In fact, it involved, we were able to eventually prove that Bruce and Barry Pollock and others eventually was proven that almost every detail in the so-called confession of Marty that forensic evidence showed was not true. It was a very important part of the case in the end, with lots of different kinds of proof. But what I'm really trying to say is, you know, DNA is often just one part of a case. You have to look at facts and evidence, even cases that are very, very old. So, watching these hearings, two things jumped out at me right away. The first is one of the lawyers for Dr. Ford is Michael Bromwich. Michael Bromwich, for many years, was a United States Attorney in the Southern District of New York. Then when Janet Reno was Attorney General, he was Inspector General in the U.S. Department of Justice. As Inspector General during the Oklahoma bombing case, credible allegations were raised by a whistleblower within the lab named Whitehurst that the trace and materials section of the FBI had very serious scientific problems, and that the analysis of the bombing, in the Oklahoma bombing case, was flawed. And he investigated that and a number of different analysts and sent a report to the Attorney General about this. It was a very big deal. And, you know, it's, I always look at it as one of the great moments for the country because, my God, they blew up the federal building in Oklahoma City, and our government recognizes that there are scientific problems, and we have an Inspector General that goes through that and exposes the problems in that laboratory and all kinds of scientific problems with the FBI lab. And they went out and actually got experts from England that redid the work and were able to prove eventually that how the explosion happened with McVeigh and offer some fairly sound scientific evidence on the point. But we did that in this country. That's quite extraordinary. Michael went on to practice at a number of prominent law firms, and then at one point we at the Innocence Project had a case of an individual who was wrongfully convicted in Houston, Texas, George Rodriguez. We were able to prove that the serology laboratory in Houston was all screwed up, to not put too much of a fine point on it. George was exonerated, and there was a huge brouhaha because everybody knew that the crime lab in Houston was going to be had a lot of problems. The police chief and mayor of Houston said we have to have an independent investigation, and so they hired Michael because he had expertise in dealing with these forensic issues, and he did the probably next to the. It was even a bigger review than the one he did for the federal government at the FBI laboratory of the Houston Police Department crime lab. Did an incredible report finding that like 70 to 80%, as I recall, of all serology cases they did in the laboratory were unsound and had problems. There's a huge review of cases there. And then eventually, the Houston Police Department crime lab now, the Houston Crime Lab, it may be the most innovative and reliable crime lab in the United States. They take great pains, by the way, to make sure that there is not cognitive bias among the analysts. So they really have broken new ground in terms of the way they hand out work. They won't tell, for example, the hair microscopist in Marty's case, I suspect, I know, probably had some prior knowledge that they were looking to see if the hair belonged to Arlene Tankliff because of their theory of the case. They try to, in the Houston Police Department Crime Lab, just send out materials. There's no reason that if you're doing a DNA test or you're looking at a fingerprint or you're looking at some other kind of forensic assay that you should know what we like to call domain irrelevant information, right? There may be at some point some reason that an analyst may have to know more about a case, but you shouldn't necessarily know what the theories are if you're just trying to look at a fingerprint or you're just trying to do a DNA test. In fact, they call it sequential unmasking. You send the biological samples from a crime scene to the analyst. They'll test them. They'll look these days at certain spikes from a certain kind of DNA test. They'll do the whole analysis, and they won't know that who the reference samples belong to. They won't know anything about who the source of the different samples are until it's all over, and they make a determination about exactly what they have. And if you can keep domain irrelevant information from the analysts and have what we call blind testing, that is a fundamental of science. If you can have these blind conditions, you should try to do it. So that's what happened in the Houston Police Department Crime Lab. So Michael is done some great work in this whole area. He was an advisor to the Innocence Project when we worked with the Department of Justice to review what's known as composite bullet lead analysis, where the Department of Justice, the FBI, recognized that when they were doing analyses of bullets that were deformed and they were looking at their chemical compositions, they would have people come in and say, this bullet came from that box of bullets to the exclusion of all others in the universe just about, or other kinds of unscientific exaggerations. They realized that they were wrong after studies from the National Academy of Sciences, and we actually had a review by the Department of Justice with the Innocence Project, the National Association of Criminal Defense Lawyers, the FBI, and the Justice Department, where we went back and tried to find all the old cases, agreed upon which times the agent analyst testified beyond the limits of science, and then we would try to find those cases and correct them if this was material evidence used in the case. Then after that, a much bigger examination had to do with microscopic hair comparison evidence, where again the Bureau recognized that their analysts had been testifying beyond the limits of science. The statistics there were quite extraordinary. They then went on to actually train a lot of the hair analysts at local laboratories. While the Justice Department had gone through this review of thousands of cases and recognized the errors, paid for free DNA testing if we could find the evidence in these cases, we've had a lot less success, unfortunately, looking at local crime labs, including New York, in terms of getting what we call hair review. One very good one was done by the Texas Forensic Science Commission, which has become the leading forensic science commission in the country, and that also came out of that Houston Police Department crime lab scandal that they set up the commission after that, and Michael Bromwich played a very important role. I can't help thinking of all of that when I watch these hearings, because he is one of the lawyers sitting at counsel table with Dr. Ford. So, good for Michael. So, let me just, before I start taking questions from you, because I have 4 more minutes, how would you think about what you're about to see as a law student, as a lawyer? Yes, this is not a criminal trial. Dr. Ford is not on trial, and Dr. Kavanaugh is not on trial for crimes. I think it's just accurate to say this is a confirmation hearing to our highest court. As many have said, it is a promotion. How do you deal with this? How should you be thinking about this as law students? What kinds of principles are at play to make judgments about credibility? What could you do if you actually had more time to do more of an investigation about what she has put forward to this committee and what other witnesses have come forward and said. Well, one thing that I always knew I would want to mention to you, and that Fred Klein and Michael and everybody else who teaches criminal law here can tell you, is something called a prior consistent statement. A prior consistent statement can be introduced into evidence in a court of law if you find that at a time where a motive for fabrication didn't exist, a witness had previously said the same thing that they're saying now. So to the extent that the allegations have been made that Dr. Ford was saying that Brett Kavanaugh sexually assaulted her when she was 15 years old in Maryland, that she had previously told her husband and a therapist, and I think there are some emails emerging where she actually put the name Brett Kavanaugh on it. If she is saying that prior to the time that she came forward, then it's a little hard to argue that the only reason she came forward now is that she's a registered Democrat or she's in league with people that want to prevent Judge Kavanaugh from getting on the court because they don't like his political philosophy or judicial philosophy. A prior consistent statement, which you'll learn in evidence class if you haven't already, there's a logic to that, isn't there? All right? Because that can be compelling proof when you think it through. Now, is that enough in a he said, she said, as everybody calls it, to get a conviction? Maybe, maybe not. You have to evaluate the credibility of the witness. But that is one way that we evaluate credibility. Investigations. How do you go about trying to deal with something in an old case like this? I was watching the hearings just before we came in here and started to talk. And one thing emerged right away that would be the kind of clue that Fred, when he was a prosecutor, Bruce, when he was a prosecutor, now as a defense lawyer, what we do all the time in innocence work when you're looking at old cases and you're trying to place a time or do a timeline of events, is that Dr. Ford said that she had seen Mark Judge, the person who she said was in the room with Brett Kavanaugh when she was attacked, who is obviously a figure that you would, in an ordinary investigation, want to talk to, who wrote this book, Wasted, who is now figuring prominently in the latest set of allegations from the last witness that came forward, that she saw Mark Judge in the Potomac Mall working, right, about 6 to 8 weeks after the attack. And that is a clear memory to her because that is the only time she saw him after this attack. And she came into the mall and she saw him and they had a conversation and he looked very, very uncomfortable. And that is one of the things that she remembers clearly. Now, what she did, she mentioned that in her direct testimony, and you could see that, and she said, well, if there were an investigation, maybe this could help me figure out the time with greater precision of the incident, because we maybe could go to the Potomac Mall and we could get records of when Mark Judge worked there or if he worked there and get better placement. That's what one does in an investigation, even before a case is charged, and certainly in these re-investigations. And I think as law students, one of the beneficial things that you can get from looking at the evidence as it comes forward in this hearing and talking with your professors who know how to do this, is to start thinking about how do you prove things, all right? There's a great movie coming out that I saw recently at the Telluride Film Festival about Watergate, all right? It's a 4-hour movie about Watergate by Charles Ferguson. It's a documentary, and it really brings you back to that period and all the events surrounding it. and it'll be coming out soon on the History Channel, maybe a short run in the theaters. It features tapes that people have really not listened to with Nixon and his aides, Haldeman, and they actually use actors to kind of read it. It's a device that actually works, but gives you a whole context of times that some of us lived through. I was 19 in 1968. I remember all of this very well. So they had this showing of the movie at the film festival, and a lot of the prosecutors showed up. And what's amazing is that there's a great book about the Watergate prosecution by George Frampton and Richard Van Benisti, who were young prosecutors on the staff of Jaworski, and who were dealing with the indictment of a president. And I would actually, if I were still doing a lot of active teaching, maybe there's an idea for you, Fred or Mike or whoever's doing this, I would do a teach-in on this movie, all right? And then I always used to teach this book, Stonewall, when I began teaching at Cardozo Law School. I used to use this book because you'll see in this movie, and if you remember it, that John Deed, the most amazing witness in history, his memory, because first he testified and then they found the tapes, and everything on the tapes exactly corroborated what he said in his testimony. But he had a key moment where he went to President Nixon, and I think it was on March 21st or 23rd, and said, there's a cover-up, there's a cancer growing on the presidency, Mr. President, and he was discussing hush money payments that they were going to give to the Watergate burglars so that they wouldn't say that they had been working, for the White House when they broke into Democratic National Headquarters. And they had this whole case, right? I think Nixon had resigned, and they were, actually trying to prove this case. And when they were making out the case, they had one of the aides, Fred LaRue, had one recollection of it, and then there was another guy that had another recollection of when they got the money to give to Comback to pay the Watergate burglars. And what was most important about this is that it had to take place, right, after this conversation with Nixon, right? In other words, before this conversation with Nixon. It couldn't take place afterwards because then you couldn't show that he was actively part of the conspiracy. And they couldn't reconcile the dates, right? They couldn't reconcile the dates. And then they found out that the money, this isn't in the movie, it's in the book, the money actually came through some guy in Minnesota, and they had to track him down, and they had to finally refreshed his recollection, and they had two witnesses that had 2 different days, and they tracked them down, and there was like this whole party at a house in Minnesota where the chimney had malfunctioned, and there was smoke all over the room, right? It's a crazy thing to think about, that the indictment of the president and these 2 witnesses that had different recollections, it actually was eventually reconciled because they're able to get the American Express receipts of one witness and refresh everybody's recollection that everything had to have happened on the day that they needed, right? Or the day that they actually had the cash movement, the actual payoff. That's crazy. By the way, if you really want to get crazy, go watch All the President's Men, and the old movie, right? And every time they say, well, let's go find something. Let's go find that person. And then the next scene, they'll have phone books all over the office, right? I mean, you live in a completely different world, but one where you can actually get proof in ways that none of us, when we started trying cases, ever dreamed would be the case. So yes, I think it's possible to reinvestigate cases that are 30 years old, and I think it would help everybody involved if they could do some more investigation in this case. I don't think whether you're a Republican or a Democrat, that is a particularly controversial thing to say. So, enough of that. I will answer any of your questions. I'm sorry I didn't have more time here, but We just had to talk about those hearings, right? I mean, it's like the elephant in the room. So please, just raise your hand. I'll repeat the question if anybody else can't hear it, and I'll answer anything that you have. About anything, by the way. Anyone? Yes.
In one of his books, Professor Alan Dershowitz, who identifies himself like yourself as a liberal Democrat, he wrote that in America, when someone is charged by the police, in his experience, they are usually actually guilty of the offense they have been arrested for. I just wonder what your viewpoint is on that thought.
So the question is, in one of Alan Dershowitz's books, he said that when people are arrested in America, they're usually guilty of the offenses that they're charged with.
In his experience.
In his experience. Well, we certainly hope so. I've heard actually Alan say that in a somewhat more flamboyant way. He says, well, if you arrest somebody and you're supposed to have probable cause that they committed a crime, right, that it's more or less more probable than not, you have some evidence of that fact, more of the people that you arrest should be guilty than innocent. This is not Iran. We are not, that's how Alan used to say it, we're not picking people's names out of a phone book before we arrest them. One absolutely wants to believe that you have some reasonable quantum of proof, right? Reasonable cause or probable cause to arrest somebody before they're ultimately arrested and their freedom is taken away from them in some fashion or form. And they're detained and brought to trial. And that's why we have elaborate procedures, one hopes, even protections of grand juries and ultimately trial by jury, in order to find out whether somebody is actually guilty or innocent. It would be a terrible system if most of the people arrested were completely innocent. That would be crazy. And then we would have to go back and totally reevaluate every way that we investigate cases. So I think that statement is correct. But I would really point out to you that we are in kind of a crisis in this country when it comes to trials. And the reason I say that is that in the federal system now, I think it's 97% of cases, right, end in pleas, and there's very few trials. In the state system, it's something like 94, 95%, okay, of cases end in pleas and there are no trials. And I think it's a fair statement that the reason that this is true is that the penalties, the mandatory minimum penalties, certainly in the federal system and in state systems as well, are so draconian, right, that a innocent person facing these kinds of charges, where there's some evidence against that individual, who could see their entire life, right, in prison in front of them, or they're facing 20, 30 years in effect without the ability to get out, versus a plea bargain, right, that is far less punitive. What is happening now is that people are not going to trial. And the problem with that, when you really look at the system in the way that your question suggests, there should be some kind of reasonable cause, probable cause that somebody has committed a crime before they're arrested. Then after that, we in theory have the protection of the grand jury, right? Actually, New York has more legal protections in grand juries than the federal system in many, many states. And the grand jury is, in theory, supposed to stand as a buffer between the state and accused, and more evidence will be brought before a grand jury before then somebody is charged, certainly with a felony in most instances. And then after that, we have a trial and we test it. The problem in this country is that if you do not have an adequately funded defense, if you do not actually have trial by jury, right, real trials, where people go over the evidence and they have suppression hearings and they look at everything that's put forward with a very critical eye and with an adequate adversary system, then all of a sudden, right, you are going to have innocent people pleading guilty, but even more to the point, you're not going to be able to protect yourself against bad scientific evidence. I mean, look, we had a lot of problems with the crime labs in terms of their own scientific standards, but a lot can be laid at the feet of defense lawyers because people did not adequately challenge a lot of this stuff for years, right? For years in various different states, we had quote-unquote dry labbing. These West Virginia, Fred Zane was the first big obvious example of it, where people weren't even doing the tests, right? Well, you know, they weren't adequately challenged to expose the fact that they weren't even doing the tests, and nobody had the resources to really do it, and people are pleading guilty without adequately testing the evidence. So whether it's forensic evidence or police officers that are crossing the line, or even prosecutors, if the defense isn't up to the challenge and the system doesn't expose them with real litigation, the whole system begins to implode on itself. And there's a very, very good publication that the National Association of Criminal Defense Lawyers just put out. I really commend it to your attention, called The Trial Penalty. And it's a very scientific study of what the differential is between the plea bargain offer and the actual sentences in the federal system, that explains why it is absolutely a rational judgment on the part of the criminal defendant, who is innocent, right, to take a plea and not go to trial. That's how draconian these mandatory minimums are, and that is a serious problem for the system as a whole.
Thank you, Professor.
Fred has a question.
Quick question, Professor. One of the most asked questions I've gotten here in the last decade is, I love criminal law from students. How do I decide if I want to be a prosecutor or a defense lawyer? And I give them my perspective, but perhaps you could give them yours, because you come from it from two different perspectives.
Well, I'm not sure we do come from it from so many different perspectives, but I'd put it to you this way. If I had to redesign a law school curriculum and clinical programs, what I would do, because I think cognitive bias is the key thing in the system. I mean, if you start as a prosecutor and you're in an office where, I mean, it's just inevitable. When you become part of an institution, you tend to see things from the institutional's perspective of the police and prosecutors on cases. If you're in the defense side, you have another kind of bias that begins to affect your perception of things. That's, you know, inevitable. We all know that from the studies of cognitive science. I think it would be tremendously beneficial if we rotated people. I would always wanted to design a clinical program where you did a year and a half or maybe 2 years, and either you start in the prosecutor's office and the next 2 years you work in the defense, or vice versa, and then we remit, you get your tuition money back, right? You pay off your tuition if you dedicate yourself, because there are those programs. I would have you go back and forth, because in conviction integrity units, the best practices that we recommend for prosecutors is there must be at least one person with great decision-making power and investigative authority within the conviction integrity unit, where you review all cases where there are claims of innocence, that was a defense lawyer. In fact, what I advise the new prosecutors is, if you want to have any credibility in the community, you should hire somebody that is a respected defense lawyer to work with you in reviewing these cases, because then everybody will think they're getting a fair shake. But most importantly, what we do in these conviction integrity reinvestigations is that we've devised a whole system whereby we share information post-conviction, we do a joint search for the truth, we try to interview witnesses together. In reviewing these old cases, we do that. We started doing that in Dallas when we began it. We have very established processes for doing it in Brooklyn. When The person claiming innocence comes in, they present a plausible case of innocence. If the unit is going to reinvestigate it, we sign an agreement with them. We give them all the work product from our investigators, not the attorney-client information, but the work product. Then they turn over the entire prosecution file, including the work product, right? And then we'll go out and get the other files. And then we try to reinvestigate this whole case together. And the worst thing that can happen, nobody goes to the press, by the way. If you go to the press, it's signed. You know, we all sign. We're not turning anything over till we, both sides, you know, agree that we've gone through the investigation. And then at that point, only three things can happen. We all agree that there was a constitutional violation or proof of innocence. The conviction should be vacated. We all agree that there isn't. Or we all say, you know, reasonable people disagree. Let's let the judge decide, but we have cut through all the problems in trying to assemble this evidence. In fact, it's a little unclear how much discovery rights exist, if any, post-conviction when you're doing post-conviction applications. So, you know, Fred, I think that the best kind of experience, certainly if you want to be a litigator, whether you go into civil work or criminal work, it's great to be either a defender or a prosecutor, but I think you want to do both sides.
Well, what I was interested in is your reason personally for becoming a criminal defense attorney.
Oh, my reason for being a criminal defense attorney? Well, it was 1968, right? When you see these movies, I was, when I got to college, I worked for Eugene McCarthy, and then Robert Kennedy. I went to the Democratic Convention in 1968 as a 19-year-old Kennedy person with nowhere to go. I was in the streets of Chicago when there was a police riot. All this is out there. Then I went to law school. I worked for the United Farm Workers Union. I was dedicated to becoming a kind of people's lawyer. That was my ambition. I spent a year writing a book about electronic surveillance law. It's a little crazy. And then I was in California, and then I'm one of the few people that moved back to New York City after living in this San Francisco Bay Area. And when I started the Legal Aid Society in the Bronx, I was with all kinds of people that thought, you know, this is, if you want to really fix the system and reform it, this is what you have to do. And when I got there, we formed a union, because when I first got in there, you know, it's kind of funny for those of you that know these things. So my office was on 161st Street and 3rd Avenue, all right? And there are a whole group of lawyers around the table. One of them now is well-known, one of my good friends, David Rudolph. You know him because he did The Staircase, right? That whole movie, criminal defense lawyer in North Carolina. Donna Lieberman, who's head of the New York Civil Liberties Union. I can name a whole bunch of other people that some in the New York legal profession would know. But you might see her on television. But we walked into our offices, and there were homeless people, drunk, and in the stairwell. And you go up a flight of stairs, and there was one telephone on the table for 6 lawyers. That was it. It was like a little table and one telephone, and that's all we had, and lots of cases. And in fact, we struck, and we refused to process more cases in the court. And when we struck, in the union contract, you will see every lawyer gets a telephone, and you get a certain amount of square feet, you know, to have a desk and an office, and so it went. So that was when we started. That's, you know, I plead guilty to being somebody from, you know, Queens who believed that the civil rights movement was, lawyers played a very prominent role, and that's the kind of thing that I wanted to do. That doesn't mean that one shouldn't go into prosecution for almost precisely the same reasons. So I really don't see the mission on either side as different. Resources may be different, but in terms of your development professionally, I think it's really important to get into the trenches and be a part of the system, be part of the action. What my friend Brian Stevenson always talks about is proximity, right? Unless you're there, unless you encounter people, as you really understand what's going on in this system, you can't change it. And that goes for whether you're a prosecutor, a defense lawyer, an investigator, a policymaker. You really have to be there and encounter people in the flesh. I see it's one last question. I'm sorry about this. Maybe two quick ones. Yeah.
Do you see any constitutional issues with the use of public DNA databases to indict people who may not know that their DNA is publicly available? For example,
You're talking about the Golden State Killer thing, yeah. The question is, are there any constitutional problems with the use of, it's what they call GEDTech, databases that have been created by people donating their DNA? I see a lot of policy problems. I don't see necessarily huge constitutional problems at this point, because in theory, everybody that gives their DNA to these databases signed all kinds of waivers. But it's kind of like the waivers that you sign for Apple, right? You know, who reads those things? I mean, we're reading them more and more now, as we should, but so I think that's a little up in the air. I don't see anything obvious in terms of constitutional terms, but I think it's a huge policy issue. And there was one more, yes.
Okay, so mine's kind of a two-part question. So how does the Innocence Project decide like which cases to take on? Like, do inmates write to you or anything like that? And like asking you to like take the cases. And another thing was, would you ever take a case where there wasn't DNA evidence, but where you thought you still had a chance?
So the question is, how does the Innocence Project decide which cases to take on? And have we ever taken on cases with there's no DNA evidence? And initially, when we began our operation, we would take cases where DNA could prove innocence, because that was a very easy way to evaluate them, and there were thousands that were coming through the door. Over the years, we took non-DNA cases as well, when there was some other compelling reason to believe that people were innocent. Among the 53 other innocence organizations in the country, I think every one of them takes non-DNA as well as DNA cases. We are taking more and more non-DNA cases, particularly if they involve unreliable forensic science. So we've recently done a number of bite mark cases. As I said, these microscopic hair cases when we got the review, or bullet lead. So we are taking non-DNA as well as DNA cases and figuring out quite how to do this. We certainly assist on a lot of them. I think out of the post-conviction DNA exonerations, the number's up to 362. Our office, the Innocence Project, has done, was either attorney of record or assisted in, I'll get the numbers a little wrong, over 200 of them, but at least 25 or 30 were non-DNA cases. So we do both. I think that's inevitable, but we still we have the most money, so we assist people in making sure that you can get the DNA tests. Okay, I think that I wish I could talk to you. I actually heard that they were taking a break at 12:40 and they were coming back at 1:40, so let's watch the rest of it.